Okay, we're on the record. Court is in session, and we're up at the main jail, but, sir, did you have a case that you wanted to call?
Page one, first on the docket is James Pennington. I'm a
Okay.
bondsman. I'm here with a friend of his.
Okay, I'm, Mr. Pennington? Are you Mr. Pennington?
Yes, Your Honor.
Okay, Mr. Pennington, you're charged with domestic battery. I have read the PC. I do not see any information regarding the relationship. I do see probable cause for a battery, but not for a domestic battery.
I agree, Judge, and I'm okay with the court finding PC for simple battery. I'm not going to ask for time.
Okay, and what are you recommending for bond?
Your Honor, as far as his prior record, he had a DUI pled out to a reckless driving with a refusal to submit to testing and then leaving the scene for anything else in '09. That was it. Your Honor, based on that and the allegations in the case, I'd be asking for a $50 bond. Looks like he said several battery arrests in the past that were dropped.
What do you say?
He had several battery arrests.
He said he had several battery arrests that were dropped.
Your Honor, I know he's shaking his head, but I'm looking right in my system here.
Can you give me some background?
Are
on
you sure
Mr.
you're not
Pennington?
talking about the alleged victim, Mr. Linder?
I'm quite sure, unless the alleged victim is James Pennington.
Can you give me some background on Mr. Pennington, counsel?
Yes, Your Honor, I can. He's a 30-year resident of South Florida. He's been at his current address for about a year. He is
Airlines for 20 years.
on him. What?
I worked for Delta Airlines for 20 years.
We worked for Delta Airlines for 20 years. He's currently on disability. He does have strong family ties. His family, his children live in South Florida. He has some money in the bank. He does not own any real estate. He's hoping that his friend will help bond him out, and he does have a place to stay separate and apart from the alleged victim while this case is pending. We would ask the court to consider pretrial release for Mr. Pennington.
I'm going to set a $1,000 bond with no contact with Mr. Walter Davies by any manner or means. Okay?
Thank you, Your
How
Honor.
much is the bond, Your Honor?
$1,000?
Thank you, Your Honor.
Okay, thank you. Okay, what about Kelsey and Kelly from this morning? The state wanted some
Yes.
time regarding an affidavit for the attempt first-degree murder.
Your Honor, what I'd be requesting, and I put in a call to BSO court liaison, and also I left a voicemail for, one moment, I'm just looking for my paperwork. What did I do with it?
Are you Mr. Kelly? Are you Mr. Kelly?
No, Your Honor, this is Cheryl Brown. I'm sorry. We want to talk about Mr. Kelly?
Kelsey and Kelly.
From this morning, Bill.
Have a seat.
Okay. Yes.
From this morning.
Sorry.
There's two. There's Kelsey and Kelly and Greg.
I'll handle Mr. Wilson, Your Honor.
Okay.
Here's Mr. Kelly.
Well, there's nothing really, I mean, if I could, Your Honor, I put in the voicemail for Detective Curtis. I've yet to hear back. Under the Florida Rules of Criminal Procedure on the, with regards to probable cause determination, it says that the court shall make a probable cause determination within 24 to 48 hours. I would ask that this be reset for tomorrow morning. As far as any potential prejudice of Mr. Kelly, considering he's being held no bond on a warrant from Judge Porter on counts 5 through 9, I don't see how he would suffer any prejudice by resetting this for tomorrow morning.
Well, I've reviewed the PC affidavit. I find probable cause on the aggravated assault.
The problem is the attempted murder, because for him to be held no bond,
But
the
that's
court,
okay, go ahead.
the court would have to find proof evident or presumption great for him to be held no bond. And without the warrant affidavit, I don't believe the court can make that determination.
I looked in here and I thought that there was a warrant.
There is a warrant, but it's just the warrant. It's not the affidavit. It doesn't have the specific allegations. And the source of the,
Kelsey and Kelly. But if there has been a warrant signed, it looks like by Judge,
it looks like Judge Jeffrey Cohen signed the warrant.
Jeffrey Cohen.
Your Honor, my concern at this point is in the Florida Rules of Criminal Procedure do require at a first appearance that for anyone to be held no bond on a punishable by life felony or capital offense, the court has to make a determination of proof evident or presumption great. Without anything in the warrant indicating that Judge Cohen made that determination, and if the court were not to make that determination here, my concern is that the defense could file a writ and that the 4TCA could find that he's automatically entitled to a bond because that determination was never made.
Okay. Because he's also being held, it looks like no bond on a...
And that's exactly, he is on the last 5 counts on a pending case, and that's why he would really suffer no prejudice by resetting this for tomorrow morning, Your Honor, because no matter what the court determines on the attempted murder, he can't get out of custody at this point.
Defense, do you want to be heard on this? I mean, I have no problems resetting this for tomorrow.
Is Mr. Atria present?
Yeah, I'm here. We don't have any affidavit, Dale. I can't read a thing.
I have no objection, Your Honor, to resetting this for the
So
morning.
we don't have any choice.
We'll reset it for tomorrow morning.
Thank you, Dave.
What about Gregory Wilson?
Make that argument today. One moment.
Mr. Wilson at the main, Dale?
Mr. Wilson is on loan. The state had sought to increase the bond. I think it was a $5,000 and a $2,500 bond. And the state was seeking to increase that, even though he's not present. I had an opportunity to review the probable cause affidavit and some of the media attention that has been focused on this case, as well as my client's criminal history. Your Honor, it would appear that there are 3 voices in the probable cause affidavit. The first one came from Deputy Brown, who was a witness to the shooting done by Deputy Johnson, who spoke through his attorney, and allegedly from Mr. Wilson himself, who made statements in the case. Neither Deputy Brown nor Mr. Wilson made any mention of an assault on the law enforcement officer, Deputy Johnson. It appears that there was an argument that escalated to a shootout, and these 2 off-duty deputies were there and got involved. Deputy Johnson shot Mr. Wilson. He claims that he refused to drop his firearm and that he pointed the firearm at him. That's Deputy Johnson. Mr. Brown, who witnessed the event, didn't mention anything about that in his part of the report, nor did Mr. Wilson mention anything about pointing a firearm at a deputy. So I would argue, Your Honor, there's actually more evidence that there's no assault on the law enforcement officer than there is. I looked at Mr. Wilson's previous criminal history, and it appears that in 2003 and 2004 he was arrested for carrying a concealed firearm, and that's the last time you see anything dealing with firearms and Mr. Wilson until this arrest. So from 2004 until for an entire decade, he's been in and out of custody. He's had a lot of drug charges. He's had a few driving charges, but he's never had a violent charge. There's only one allegation in his history that could be considered a violent charge. That's the 2008 battery case that was dropped by the state. So I would argue, Your Honor, that the community is not in any danger by allowing this man to bond out on the current bond as set. There's no need to increase the bond, nor is there any need to add a pretrial release requirement. I don't believe the state has made any indication of whether he's ever missed a court date before. And so I would just ask the court to leave the bond as currently set.
And State, what are you asking the court?
Your Honor, my response would be, Your Honor.
But I mean, just the amount.
Okay, Your Honor, I would be asking for $15,000 bond on count 1, $5,000 on 2, with a pretrial release with a GPS monitor.
Okay, what I'm going to do is raise count 1 to 10,000, leave count 2 at 2,500, and of course, he can always seek to lower the bond or change the bond
And Your Honor,
once he comes back.
I have no objection to that, Your Honor. As far as the state's request for pretrial with the GPS monitor?
No, I'm not going to do it.
Okay.
Thank you, Your Honor.
Okay. The next one is Cheryl Brown. Yes.
Your Honor, Ms. Brown is present in the main.
Okay, Ms. Brown, you're charged with criminal mischief over $1,000. I'm assuming that is a felony. I do find probable cause. You have a bond of $500, and you have a violation of probation in which there is no bond at the present time. Do we know when she'll be appearing before the probation judge?
What'd you do with the document?
Ms. Brown, you're going to be appearing before the judge on the violation of probation on 12/10 at 8:45. Thank you. Peggy Jimmy?
Main jail, Your Honor.
Ms. Jimmy, you are charged with criminal mischief, $200 or less. That is I believe, a second-degree misdemeanor. I find probable cause. Your bond is $25. You also have a violation of probation, hold on you or warrant. No bond. And do we know when Ms. Jimmy will be appearing before the judge? Okay. Thank you, ma'am.
Yeah.
Yes.
For the record, Your Honor, Miss Jimmy had declined the services of the public defender.
Okay, thank you, ma'am. Jatura Bradley?
North Broward?
Jatura Bradley?
I didn't speak with her.
North Proud, Your Honor.
Thank you. Good afternoon, Ms. Bradley.
Hi, Your Honor. How are you this evening?
Good. How are you?
Afternoon.
You are charged with
Okay.
possession of cannabis less than 20 grams. In reading the probable cause affidavit, I did not find probable cause.
Okay, and I'm not.
Her bond is what? Oh, her bond is posted already? Ma'am, your bond was posted already, so you'll be released soon. Okay?
Could you call
Okay.
SPU?
Thanks, Your Honor.
Thank you.
Have a great afternoon.
You too. Thank you.
That's SPU. Both of those cases. Well, I gotta try.
Jonathan Ford.
Present at the main, Your Honor.
Mr. Ford, you're charged with driving while license suspended. Your bond is $100. Find probable cause. You're also charged with a civil infraction of driving a vehicle without lights. And there's a capias issued for another driving while license suspended, issued by another judge, and it's $500. Thank you.
Thank you.
Errol Esther?
That's a municipal ordinance main jail.
Your Honor, Mr. Esther is present at the main.
Mr. Esther, you're charged by the city of Fort Lauderdale with trespassing. I have read the probable cause affidavit. I find probable cause, and your bond is $25. Okay, sir? Thank you. Walter Walker?
North Broward?
Your Honor, that's going to be a North Proud medical reset.
Thank you. David Perez?
Yes. Main jail, declined PD, Your Honor.
Mr. Perez, good afternoon, sir. You're charged with
Good
possession of
afternoon.
cannabis less than 20 grams, first-degree misdemeanor. I do find probable cause. Your bond is $100. You have an out-of-county hold, from Brevard County. Your bond on that count is $500. And you're charged with possession of drug paraphernalia, first-degree misdemeanor, and I'm RORing you on that count, okay? Thank you, sir. Clint Kilgore?
North Broward?
North Proud, Your Honor.
Okay.
Your Honor, I printed out, if you'd like to review it, because I know it wasn't attached. These are ad charges. I printed out the original PC affidavit if you'd like to see it, Your Honor.
Well, when I looked at this, I saw that there was a bonds already set at pursuant to
They were set by, they're the convenience bonds. They've never been set by a judge.
Okay.
So I just thought if you want to see it.
Yes, that would be great. Thank you. Mr. Kilgore, apparently you have already been magistrated, I'm sorry, on the charge of aggravated battery,
Yes.
in which a bond was set of $7,500. The state has added 3 charges. One is attempted armed burglary of a dwelling. Number 3 is stalking, aggravated stalking, and number 4 is aggravated stalking. Just give me 1 second.
Hey, it's Eric. Hey, are you submitting the stuff to the clerk for Tony Gibbs? Can you put someone in, could you get in touch with someone in e-filing in the clerk's office and have them call me at 0649? I'm wanting them to come to the courtroom to tell the judge that we did file it. Because it's not, obviously, it's not updated. So could you have someone from e-filing that you know give me a call at 0649, please?
On what?
Okay, thank you. Okay, thank you. Bye-bye.
State, are you asking for an increase in bond?
Your Honor, I would be asking for count 2 to be increased to $5,000, and based on the totality of the circumstances in his priors, criminal mischief last year, dealing in stolen property 2011, burglary of a dwelling 2011 with the VOP, just over 31 months in state prison. In addition to the bond increase to $5,000 on count 2, I'd be asking for pre-trial with the GPS to ensure the alleged victim's safety.
Okay, Mr. Kilgore, I've read the probable cause affidavit. Find probable cause for the add charges of attempted armed burglary, stalking, aggravated stalking, and another count of aggravated stalking. Well, wait a minute.
May I be heard over at the main, Your Honor?
Yes, sir.
Regarding Mr. Kilgore, I may be out of line here, but I believe that if another judge has set the bond, that the magistrate court doesn't have the authority to adjust that. And so if Judge Bober set the bond in this case, then I don't believe this court has authority to change that.
Oh, I would agree.
I may be wrong.
No, I would agree with that. Was it Judge Bober that set the bonds?
Where does it?
I don't.
Wait,
I
what-
don't have that information.
Your Honor, if I could, 1 moment. My understanding was these automatically get set to the convenience bond with the ad charges, and that Judge Bober, he hasn't even been arraigned on this case yet.
Yeah, are you
Okay.
talking about the corrected caveats? That looks like to me that it's just going to be assigned to Judge Bober, but Judge Bober did not set it.
Got it. Thank you, Your Honor.
I do have a question, though, as to the second
Actually-
aggravated stalking. Who would be looking at the?
I have the information right here, Judge. There was 1 count regarding Holly Lawson, and another for Eric Fuller.
Okay, I am going to grant the state's motion as to count 2 and raise the bond from 1,000 to 5,000 based on the probable cause affidavit. Mr. Kilgore, you have a total of $22,500 bond. Alexander Rodriguez?
I'm sorry, Your Honor.
Oh,
I hate to keep doing this, but I believe that even though the state ad charged him, Mr. Kilgore, with these charges, that Your Honor still has to find probable cause on them.
I did. I read the probable cause affidavit.
Oh, okay. Because we didn't see it. We didn't have a copy of it. All we had was the warrant.
No, I do have the probable cause affidavit right here.
Thank you, Your Honor.
Okay, thank you. Mr. Rodriguez? Is that you, sir?
Paul Ryan. Paul Ryan, Your Honor.
Thank you. Mr. Rodriguez, good morning, or good
Hi there.
afternoon, sir.
Good afternoon. I have a private attorney, and I want to know if he can be present or contacted.
Absolutely. Who is that?
His name is Michael Becker.
Michael Becker.
Yes, sir. He's at a Woodland Manors.
Why don't I reset this for tomorrow morning, and you can contact your attorney, Mr. Becker, and tell him he's going to be here?
Sure. I don't have his telephone number. I wasn't able to get his number out of my cell phone while before I was detained.
Yes.
Deputy Parrish.
Right now. Okay? That's not a problem. Mr. Rodriguez, we're going to call your attorney and see if he can't be here tomorrow morning or maybe tomorrow afternoon, depending on his schedule, okay?
Thank you. Would I be able to have his number so I can contact him as well to speak about my case?
Well, we're going to look up his number right now.
Thank you so much.
Could you do me a favor?
Does the judge look it up on his computer?
I think I have it, Judge. I'll give him a call, Mr. Becker a call. I can give Mr. Becker a call if you want, or if you want to call.
No, I'll call him right now.
Okay. Number I have is 305
It's 954?
91305. 305 area code.
954.
No, it's a 305 area code.
I thought he said he was up.
Sorry. Yeah. Well, I mean, this is the only Michael Becker I saw.
305.
727 5067. Could you try this on?
That's not the number that I know of. That's not the number that I know of. Okay. That's like 742.
No longer in service.
I'll try one other thing.
One other number.
Well, yeah, but he does have a 305 number.
Hold on, sir.
I know I can contact someone who has his number. I don't know if that's possible.
Okay. Let's see if this works.
You're looking at the Florida bar.
Yes, I have another 305 number. 305 538 0520.
Maybe got an alternate number.
Wait, did he mean Becker or Baker?
Did you say Baker or Becker?
Becker. Becker.
Thank you.
His first name's Michael.
Yes, Judge.
Mr. Becker, my name is Christopher Pohl. I'm a judge up here in Broward County. And we're at magistrate. Good, how are you? We have a defendant by the name of Alexander Rodriguez who is asking us to reset his magistrate hearing for tomorrow, wondering if you could be here to represent him.
Well, I just got off the phone with his mother about 10 minutes ago. What time in the morning?
Well, it starts at 8:30, but usually we're here all morning, or we can set it for tomorrow afternoon at 1:30.
Yes.
Well, it's the magistrate first appearance hearing, and yes, so bond is part of it.
Here's the thing.
So he's in the courthouse right now?
I'm in first
Well,
appearance.
no, he is
and I got a
presently
motion to
at
release
the
him from the judge
Paul
court,
Ryan Center,
and I need to give
and
Judge
we're
Pohl proof
magistrating
that
him
he
through
received
video.
it. Is there any way maybe you or someone could just come up? I'll have the case called immediately when you
Well,
get here. But is
what
there
we'll
maybe
do is
somebody
we'll
you could just
set
tell
it at
Judge Pohl
8:30,
that
but
he
whatever
received
time you can be here, we'll be here all morning.
filing from the state attorney's office?
Usually I'm there like 9:30.
Oh,
That would be
okay.
great.
All right, let me call.
And your name again?
My name is Christopher
Wait,
Pohl,
you guys did
P-O-L-E.
receive information from the
I'm
state
the
attorney's
judge
office,
today.
correct?
There'll be a different judge tomorrow.
All right, it's a pleasure speaking to you, and thank you very much for calling.
Okay, so
Okay,
would
sir,
you be able
thank
to
you.
come up
Bye.
and say that you have received an information from the state?
Okay,
I mean,
so
I
we're gonna
mentioned
set
there's
Mr.
been some
Rodriguez
computer issues with
tomorrow
the
at
clerks,
8:30.
with Odyssey in the clerk's office and whatnot today.
Thank you.
Thank you. Parker Schaefer?
Would you be able to
President
tell the
Maine?
judge that the clerk's office has received an information from the state?
Mr. Schaefer, good afternoon. You are charged
afternoon.
with failing to return a leased vehicle, which is a felony. I do find probable cause. Your bond is $1,000. You're also charged with possession of cocaine. I do find probable cause, and your bond is $1,000. Thank you.
Your Honor,
Yes, sir.
Mr. Schaefer is if I may, he's a 2.5-year resident of South Florida. He's been at the same address for the past year. He's currently unemployed. He does have some money in the bank. He does not own any real estate. He's hoping his friends will help bond him out. We were wondering if the court would reconsider pretrial release for him.
State, objection.
Just seeing if he's ever had any prior records. I'm not seeing any priors, Your Honor.
Okay. I will ROR him on both charges and order pretrial release standard. He's to report twice a week by phone. He is to report once a month personally to pretrial release.
Yes, Your Honor. I'll give him the reporting instructions.
Okay, thank you. Rudy O'Brien,
Bonded.
Main jail.
He bonded, Judge.
Oh, he did bond?
That's what I'm showing.
Okay.
Sheila, are you showing that?
What about Julius? What was this gentleman's name?
This is Mr. Clark, Your Honor. Hello.
Julius Clark, okay. Mr. Clark, you are charged with possession of cannabis less than 20 grams. I do find probable cause, and you are ROR'd on that count. I'm sorry? Julius Clark? Okay, so Mr. Clark, your bond is posted. You're going to be released soon.
Your Honor, after this case, if we could call a case out of turn, please?
Yes.
Tony Gibbs, it's on the second felony docket. It's a motion to release.
You mean I don't have, it's on one of these?
Yeah. Which one is it?
Tony Gibbs.
Okay, we're looking at Tony Gibbs on page 4.
He's not in the main.
And it's a defense motion for ROR.
Yes, for if the state filed an information or not, Your Honor. Your Honor, I'm sorry, your name again?
Ozzy.
Your Honor, this is Ozzy from the clerk's office.
Oh, you, Ozzy.
We're having there's some issues, my understanding, with the computers today. So normally what we would present to Judge Hurley is the register of actions from the clerk's office showing that this information has been filed with the clerk. There's some issues with the computer, so it's not being updated. I asked Ozzy here today to inform the court that that the clerk's office has received an information from the state attorney's office in this
Okay.
case. Well, I mean, it was today, right?
We received the filing today, yes.
Okay, so where is Mr. Gibbs?
I'm checking that right now.
North
Your Honor.
Broward.
North Broward.
He's
Okay.
at North Broward.
Not bad, Mr. Gibbs. You want him?
Yes, is Mr. Gibbs there?
Yes, sir.
Does he have, is there a bond on Mr. Gibbs?
Your Honor, yes.
Because I don't have any paperwork.
He has a $750 bond that's based on.
That's you, right?
Because it looks
Yeah,
like,
that's Tony Gibbs. Just want to make sure.
Mr. Gibbs, yes, sir, that's who we're on.
Okay. Yes, sir.
So a misdemeanor information was filed.
No, a felony.
Oh, it is a felony. Okay, and his bond is presently, does anybody know?
$750.
Okay, let me write that down.
You have a felony?
Mr. Gibbs? Mr.
Yes.
Gibbs, an information has been filed on your case. It's a felony information, and your bond is $750. Okay?
I have a misdemeanor, sir.
No,
I have
it's
to
a-
pay debt.
It's been filed as a felony. Okay? Thank you, sir.
Thank you, Judge.
Okay. 750. Right. Guy Adani? Mr.
Present at the
Adani?
main, Your Honor, he has declined the public defender services.
Okay, Mr. Adani, you're charged with possession of heroin. I find probable cause. Your bond is $1,000. You're also charged with possession of cannabis, less than 20 grams, a misdemeanor, driving while license suspended with knowledge, a misdemeanor, and failing to wear a seatbelt, which is a civil infraction. On both misdemeanors, I'm RORing you on those 2 counts. Your total bond is $1,000. Thank you. Nicholas Register?
Present at the main, Your Honor.
Mr. Register, you're charged with driving while license suspended, a misdemeanor. I find probable cause. Your bond is $25. You're also charged with unlawful speed, which is a civil infraction. You do not have to post a bond on that. You have 2 violation of probation warrants signed by Judge Destry, in which he has indicated there's no bond. Thank you very much.
Thank you, Your Honor.
Philo Little, or Philo Little?
Mr. Little has declined the public defender services, Your Honor.
Okay. Mr. Little, you are charged with possession of methamphetamines. I find probable cause. Your bond is $1,000, and you're also charged with possession of drug paraphernalia, in which I'm releasing you on your own recognizance.
Thank you, sir. Good luck.
Okay. Mr. Little, you are apparently on pretrial release for these 2 charges?
He was just arrested 6 days ago on December 2nd, Your Honor. For possession of methamphetamine and drug paraphernalia.
Okay, so the same thing?
Yes.
Okay, and he was placed on pretrial release?
Yes. Got out last Wednesday.
Okay, so I'm revoking your pretrial release, and pursuant to the rule of criminal procedure and the statute, I'm finding that while out on pretrial release, you committed another criminal offense, so I'm setting no bond at this time on your other 2 cases.
Case numbers,
on your other case.
Case number, please. Case number?
Just give me 1 second, I'll get it for you.
Yes, you need, on the old case, 14 016 066 CF10A. Okay. I'll give you this. You need.
Sure.
I'll give you this.
All the other 30 days are ROR.
And lastly is Aquilino Gonzalez.
Your Honor, before you close the book on Mr. Little, I was wondering if the court would consider giving him an order allowing him to participate in the SAP program, substance abuse program here at the Sheriff's Office.
Yes, I would agree with that.
Okay. Mr. Atria, can you give us a hand on that?
Got it.
They'll prepare the order. I'll sign it. Aquilino Gonzalez. Mr. Gonzalez, good afternoon, sir. You're charged with possession of cannabis less than 20 grams, a misdemeanor. Your bond is $100. I do find probable cause. You're also charged with possession of drug paraphernalia. Your bond is $100. I find probable cause. And there's also a violation of probation in which you have no bond. Thank you, sir.
Thank you, Your Honor.
That's all that's left.
All right, so
Really no other choice.
there are 2 dockets, right?
Yes.
Okay, so let's.
Your Honor, with the court's permission, I've got 3 guys here at the main. Can I go ahead and call them up?
Yes.
Thank you. Come on, line up, guys. What's your name?
Antonio Battle.
Antonio Battle, Your Honor?
He's got 2 cases on the felony motion to release docket.
Right.
Your Honor, we have not yet filed charges on either case, so he is entitled to an ROR on both cases.
Okay, thank
Battle,
you.
B-A-T-T-L.
Thank you, Mr. Battle. The state has not.
Hey, good afternoon. Good afternoon, Your Honor.
I'm sorry?
Good afternoon, Your Honor.
Oh, thank you, sir. Good afternoon. Mr. Battle, the state has not filed charges on your cases yet, so I'm going to release you on your own recognizance on both cases, okay?
Okay,
On
thank
all
you.
counts.
Thank you, Your Honor. I have Leon Rodriguez here for a second look, Your Honor. You're William Rodriguez?
There you go. I'm sorry, what's his name?
Leon Rodriguez, Your Honor.
Okay, this is on the misdemeanor.
This is,
Leon Rodriguez, page 2. On the second looks, I would assume that the judge reviewed it, they did not find probable cause.
no, Your Honor, what happened here, this is from a capias.
I understand.
It originally was a notice to appear. I believe the issue the court had with resolving it is that it is a criminal mischief. There could be potential restitution issues. And like I said, it's a capias, so the bond was already set by his judge when he failed to appear in court.
What I think should be done would be that he go before the judge that issued the capias.
Well, what's going to have to happen is he's going to have to get assigned a central judge because this is out of North Satellite, and they can't, if he remains in custody, they can't transport him.
I see.
But I have no objection to having a central judge assigned as quickly as possible and getting him over there before that judge just as quickly.
All right, so on Mr. Rodriguez, I'm going to order that it be assigned to the central and to be assigned to the judge, and that a hearing be set before him for an arraignment. Okay, Mr. Rodriguez?
Thank you, Judge.
Can I get R&R?
He's looking for an ROR, Your Honor. I've tried explaining to him why that's not possible, but maybe you could take a shot at it.
It's not possible.
So how does it work?
What we're going to do, sir, is assign your case to a judge here at the Central Courthouse because you're in custody, and we're going to get you in front of that judge as quickly as we can for an arraignment. And at that time, you can look at resolving the case or reducing your bond.
You know how soon that would be?
It'll be this week.
There you go.
Okay, thank you.
Thank you, Your Honor. Finally, Your Honor, we have William Rodriguez, who's
I
here
have
at
one
the
more
main.
question.
Go over there and I'll answer your question in a minute.
Willie Rodriguez?
That might have been.
Leon has another question. Go ahead.
Can I get a bail reduction?
Okay.
No, sir, not at this
Can we
time.
just-
You're going to have to go before the other judge.
And then where we start?
Well, here, let me.
Okay, Mr.
Huh, yeah.
Well,
I don't.
And the last one is who?
William Rodriguez, Your Honor.
Yeah, I
and
don't have him
think
on
he's
any-
also here.
I don't see that
For a
on the
second.
dockets. Not on either docket, Dale.
Yeah, I know, but the deputies looked him up on their internet site, and apparently he was set for magistrate today. He doesn't know why he's here either.
Here, I'm checking this right now, Your Honor, just to see what he's being held on.
Need a date of birth?
No, I've got it.
Okay.
Uh,
Mr. Rodriguez,
That's
are
weird,
you
Your
okay?
Honor. He's being held on a $1,500 felony VOP for possession of cocaine. So there's really nothing that we could do from out of this division, at least.
Okay.
If you give me a second, I'll check in Odyssey to see if he's got a court date coming up.
Mr. Rodriguez, you're being held on a violation of probation warrant out of felonies. That there's a $1,500 bond, and we're going to check to see if you have a date.
Is he scheduled to see Judge Rothschild tomorrow morning for his VOP?
You're scheduled to see Judge Rothschild tomorrow morning. Okay? All right, sir. Thank you. Is that all at Maine?
That's it, Ed Bain, Your Honor. Thank you very much.
All right.
It's a pleasure working with you today.
Thank you
Your Honor,
very much.
Conti's ready.
You got it.
And why don't I go through the felonies first?
Those will be quick.
Henry McBride.
Conti. Oh, nope. Sorry.
That's all right. It looks like the public defender.
Let me just see if I can.
Sorry?
I'm just checking real quick to see where it shows what facility he's in.
Henry McBride, anybody know where he's at?
Main jail.
Nope.
You know, this is weird. I'm showing Maine also, but you know what? Your Honor, we haven't filed the information yet. He's entitled to release. I'm sure the defense will waive his appearance and.
Okay. On Henry McBride on page 2 of the felony docket, then I'm going to ROR him on all 3 counts. And then we'll go to Christopher Sullivan.
Conti, Your Honor.
Your Honor, we have.
Christopher Sullivan, good morning, good afternoon, sir.
Your Honor, the state has not yet filed. The state has not yet filed an information on Mr. Sullivan's case. He is entitled to release today.
Mr. Sullivan, I'm going to release you on your own recognizance on both counts of your charge, okay?
Thank you, sir.
Thank you. 140-146-42 CF10A. Rosemary Sutton? That would be North Broward, wouldn't it? No?
Your Honor, she's out to 8 p.m. court, room 415.
Your Honor, we have not filed an information, so she is entitled to release also.
Okay, on Rosemary Sutton on page 4 of this felony docket, I'm going to release her ROR on all 3 counts. It is 14-014-850 CF10A. And then we have Nicholas McDuffie.
North Broward, Your Honor.
North Broward.
Your Honor, we have not filed an information. He's entitled to release. I would just ask Your Honor if you could advise Mr. McDuffie that even though he's being ROR today, the no victim contact order that Judge Hurley ordered in November is still in place.
Okay, Mr. McDuffie, good afternoon, sir.
Good afternoon, hi.
Mr. McDuffie, the state has not filed an information on your case yet, so I'm going to release you on your own recognizance on both counts. But I do want to let you know and inform you that Judge Hurley entered a no contact order as part of your pretrial release back in November, and that's still in full force and effect. So you cannot have any contact with the alleged victim in this case. Do you understand, until this case is resolved? Do you have any questions about that?
Okay.
Okay, thank you, sir.
Thank you, sir.
14-014-860 CF10A. What about Tony Gibbs?
That's the case we handle with the
You're right, I remember.
Ozzie from the
Okay,
clerk's office.
so that's the felony docket. We go to the misdemeanor docket. Charles Meyer.
That was the case with the city attorney for Hollywood.
Right. Is Mr. Meyer still in the facility? Mr. Charles Meyer? No? Not at Conte?
It shows main jail, sir.
Charles Meyer?
Deputy, was there a Mr. Meyer at Maine?
You have a Mr. Meyer there? Charles?
They definitely don't.
Stand by.
Okay.
We didn't have that sheet, did we? We should.
Let's go on to somebody else until we can find him. What about Norma McFadden?
North Broward, Your Honor.
Yes, sir.
Miss McFadden, how are you doing? I'm just
Not so good.
not so good. Just give me 1 second so I can find your.
Yes, sir.
It's an MO. Okay, let me just try to find it. And these are the second look. Yes. I'm just not finding her case. Yeah, I don't see it here. Norma McFadden.
Yes, sir.
Ms. McFadden, you're charged by the city, I believe it's of Fort Lauderdale, for prostitution
Yes.
or loitering.
Yes, sir. Yes, sir.
Okay, so we don't have a file. Does anybody know what her bond is?
300.
300. Can you make it, ma'am? You can't.
No, sir, I can't.
You can't.
No.
Do you? I'm sorry. Please. Do you live in Broward County?
Yes, sir.
What's your address? Well, never mind. Hold on. Ms. McFadden, do you want to resolve this today, or do you want me to set a bond?
No, I want you to resolve it today, sir.
You do want to resolve it?
Yes, sir.
Do you swear to tell the truth?
Yes, sir.
Okay. Please state your name.
Norma Jean McFadden.
Ms. McFadden, it's my understanding you wish to resolve your case today and waive your right to an attorney into trial. Is that correct?
Yes, sir, I will.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
Yes, sir.
Are you on medication?
Yes, sir.
Did you take it today?
Yes, sir.
The fact that you took this medication and that you suffer from this illness, is it preventing you from understanding the proceedings today?
No, sir. It's just for manic depression.
Okay. Are you pleading no contest to the prostitution
Yes, sir.
charge?
Yes, sir. No contest.
The court's going to accept your plea of no contest, find that it's freely and voluntarily given. The court is going to adjudicate her guilty, sentence her to 5 days in the Broward County Jail with credit for 5 days time served, order court costs of $293, and I'm going to give her 6 months to pay that. Okay, ma'am, thank you very much. What about Leon Rodriguez?
We handled that.
We did, okay.
That was the criminal mischief.
Mr. Meyer? Yeah, that would be great if they could do that, and we'll finish up. And what about Robert Khalib? Okay, so Robert Khalib is to be reset.
Main jail, bring down Mr. Charles Meyer. Thank you.
We're going to wait for him, but we're going to move on. In other words, if we can get a hold of the jail. What about Bernard Malone?
You didn't hear me?
Conti, Your Honor. Malone. Oh.
Mr. Malone?
Yes, sir.
Mr. Malone, you're charged with trespass by the state. Does anybody know what his bond is? Alone.
I believe it is. Yeah, it's 500 on this. He's got some other stuff too, though.
Okay, well,
but
we're just talking about this one.
Yeah. And as far as the allegations,
I have it right here. Thank you. Okay, Mr. Malone, you're charged with trespass.
Yes, sir.
Your bond is $500. Can you make that?
Yes, sir. Yes, sir.
Okay.
No, sir.
You can't make it?
No, sir. I'm homeless.
I see. Okay. Do you want to resolve your case today?
Yes, sir.
Is anybody, do you swear to tell the truth?
Yes, sir.
Are you waiving your right to an attorney in the trial?
Yes, sir.
Do you understand you have those rights?
Yes, sir.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
Yes, sir.
Are you on medication?
Yes, sir.
Did you take it today?
Yes, sir.
Is it preventing you from understanding the proceedings, or do you understand everything that's going on?
I understand.
All right. And are you pleading no contest to one count of trespass?
Yes, sir.
The court is going to accept this plea of no contest, find that it's freely and voluntarily given. The court is going to adjudicate him guilty, sentence him to 5 days in the Broward County Jail, credit for 5 days time served, order court costs of $293, and give him 6 months to pay. Thank you, Mr. Malone. Frank Smith.
Conti, Your Honor.
So battery case, his bond was raised to $5,000.
Okay, let me. Good afternoon, sir.
How you doing?
Good. And we don't have a file on him. Do we know why we reset this? Just because he's been in for 6 days? Yes. And it's a battery charge? And what is the bond?
$5,000.
And is it a felony or a misdemeanor?
It's a misdemeanor, Your Honor.
Pre-trial, do we have any information on Mr. Smith? Did you interview him? That would be great if you have it. Thank you.
And I have some additional information when the court is ready.
Okay, just give me 1 second.
Sure.
You could be.
Mr. Smith, are you under mental health care now?
No.
Do you take any kind of medication?
No, sir.
Okay. Yes, sir.
In late October of this year, a woman who's not named in this case at all obtained a injunction order of protection against Mr. Smith, and that's in place till October 21st of next year. Additionally, he was arrested in May of 2012 in Cape Coral for domestic violence battery. That ended up being dropped in June of that year.
Mr. Smith, where this incident occurred, is that where you live?
Yes, but I have other arrangements already in plan. So, if you pre-trial release me, I wouldn't stay there.
Okay. Anybody have any objection to pretrial release? No contact with reporting? Okay, on Mr. Smith, I am going to release you on your own recognizance into pretrial.
Okay.
And you're to report by phone twice a week.
Okay.
You're to report personally once a month.
Okay.
And you are not to have any contact in any manner or means with Joshua Matlock until the final disposition in this case, okay?
Yes, sir.
Do you have any questions?
No, the office for pretrial, is that in Fort Lauderdale? Oh, never mind. The officer gave me the paperwork.
Very good.
Thank you.
Okay, thank you.
Mr. Byers here at the main jail.
Jail. Who is this gentleman?
You're talking to Conti?
Myers, Charles Myers.
Main jail.
Okay, Mr. Meyer, good afternoon, sir.
Good afternoon, sir.
Mr. Meyer, you're being held. Right. Yes. No, no, no. There. Okay, hold on. It looks like no lodging on city-owned property, right, for Mr. Meyer? With a bond amount of $100. Do you understand that, sir?
Yes, sir.
Okay, and that was pursuant to a capias. Did you want to resolve your case today?
Yes, sir.
Okay, what I'm going to do is withhold adjudication. I must order court costs of $293. And I would give you 6 months to pay that. Do you want to do that?
I agree with it, sir.
Say that again?
I agree with it.
Okay. Do you swear to tell the truth?
Yes, sir.
And state your name.
Charles Meyer.
Mr. Meyer, it's my understanding you wish to resolve your case today, waive your right to an attorney in the trial. Is that correct?
That's correct, sir.
Anybody forcing you to do this?
No, sir.
Are you under the influence of drugs or alcohol today?
Oh, sir, just medication.
And
I know, we got the paperwork we need.
Why
We
are
can
you
deal
on
with it now.
medication? For what?
Why are you on medication?
Oh, that is detox.
I see. Have you ever suffered from a mental illness?
No, sir.
And are you pleading no contest to the charge of lodging on city-owned property, which is a trespass?
Yes, sir.
The court's going to accept this plea of no contest, find that it's freely and voluntarily given. The court is going to withhold adjudication, order court costs of $293, and we give you 6 months to pay that.
648 submission. Sheila?
Yeah.
I thought 648.
And Your Honor, just so you know,
This is a withheld. That's what the city offered. They were here earlier.
we got the affidavit on Kelsey and Kelly, the attempted murder. So we're having the jail bring him back rather than have to deal with it tomorrow morning.
Okay.
I don't know if they can get him in time because...
Yeah, Mr. Atri is reviewing the affidavit.
Ask Sheila where he at. I don't know where
What
he
about Bradley Byram?
Okay.
It's trespass, state charge.
Do I get any paperwork?
No, not right now. Where?
Mr. Byram there?
All right, enjoy. All right. Bellamy, wait,
Bradley Byram.
Bradley Byram.
You know, here, one moment, Your Honor, I'm going to check.
Bradley Byram? At Conte, no?
No, sir, it's showing main jail.
Well,
Main jail.
Your Honor, I'm checking right now. He bonded out. He's out of custody.
Okay, Bradley Byram's going to be deleted from the docket. He bonded out. What about Willie Sims?
Conti, Your Honor.
Mr. Sims, let's see if I can find your case.
Go behind me.
How you doing, sir?
Good, how are you?
I'm doing all right, and you, sir?
I don't have a file on Willie Sims. This is a second look, apparently.
Yes, Judge.
And Mr. Sims, you're charged with disorderly conduct, trespass after warning, and another count of disorderly conduct. Does anybody have a PC or a bond?
One moment, Judge. Sims.
Willie Sims.
Yes, sir.
It's an MM case.
Yeah. Sheila, do you have PC for Sims?
Thank you.
It'll be alright. You got two? A tower, B tower. I got two B and one A. What is this?
Mr. Sims, I've read the probable cause affidavit. I find probable cause for the disorderly conduct, but I don't find any probable cause for the trespass or the second disorderly conduct.
Your Honor,
Did you want to be heard on that?
well, yeah, in fairness, Your Honor, and probable cause was already found by Judge Diaz when he first came through. This is really just for bond review.
Okay.
The issue being, if the court had an issue at its first appearance for probable cause, the state would have only had 24 hours to perfect. We're well past that, so the state wouldn't legally have an opportunity to perfect at this point.
I see that Judge Diaz signed on 12/5 that he found probable cause. Bond is at $100 on count on the disorderly conduct.
Yes, Judge.
$100 on, well, it says here resisting officer or without violence. I would certainly find probable cause for that. That's $100, and then trespass is $500.
And Your Honor, and I guess the reason Judge Diaz found PC for trespass is the part of the second page when the deputy wrote, I asked Sims to leave the premises several times, and he repeatedly told me no. I do whatever the blank I want. I'm not going anywhere, so blank you and your badge.
Well, he began walking to 1404 Northwest 6th Avenue, I guess a grocery store. But it does not, well, anyways, he's found probable cause,
Yeah.
so that's done.
Well, sir, excuse
Mr.
me.
Sim, can you make a $700 bond?
No, sir. Can I reserve the case today, sir?
Can you do what?
Can I reserve it today? I don't have no one out there, sir.
Your Honor, just so you know, I believe part of the bond increase might have to do with his prior record. 2011, uttering a forged instrument and theft, just over 21 months state prison. 2011, possession of cocaine with intent to sell or distribute, same sentence. 2012, resisting without violence and trespass. 2007, trafficking in oxycodone, 36 months state prison. 2007, possession of cocaine with intent to sell or distribute, 36 months. 07, delivery of cocaine, 36 months. 04, possession of marijuana. 04, loitering and prowling. 04, trespassing on school grounds.
Okay, Mr. Sims, if you do want to resolve your case today, I would sentence you to time served, not on the charges on the docket, but the charges on the probable cause affidavit, which is disorderly conduct, resisting an officer, and trespass.
All right. I'd like to reserve that today, sir.
All right. Do you swear to tell the truth?
Yes, sir.
And are you waiving your right to an attorney into trial?
Yes, sir.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
Yes, sir.
And are you on medication?
No, sir.
Is your illness preventing you from understanding the proceedings today?
No, sir.
Okay. And do you wish to plead no contest to one count of disorderly conduct, which was regarding a fight? One
Yes,
count
sir.
of resisting or obstructing a police officer without violence, a misdemeanor, and
Yes, sir.
trespass.
Yes, sir.
Okay, the court is going to find that his plea is freely and voluntarily given. The court is going to adjudicate him on all three counts. Sentence him to 6 days in the Broward County Jail with credit for 6 days' time served. Order court costs on count 1 of $293, 6 months to pay, and I'm going to waive court costs on count 2 and 3. Okay, good
All
luck
right,
to you,
sir.
Mr. Sims.
All right. I mean,
Kelly's
I'm
at the main jail.
You go to B7.
And what about Diamond Shindney?
Oh, Your Honor.
Shoot. Shoot.
Are you Mr.
getting him?
Shindney?
Yes, sir.
Let me see if I can find anything on him. Here it is. Okay. Thank you. Mr. Shidney, you are charged with driving while license suspended, and you have a bond of $500. Can you make that bond? Do you have
No,
anybody
sir.
that can post that for you?
No, sir.
Okay.
Okay.
The DL records. We happen to have one on Mr. Shidney. No, I took them all out. Let's see.
I can talk. I was wondering, sir, if there's any way we can resolve it today.
Well, Mr. Shidney, one of the problems is that if this is a third offense within 5 years, and you're convicted of it, or even if I withhold adjudication, then your license will be suspended for 5 years as a habitual traffic offender. And I can't advise you as to that because I don't have a DL record on you.
Yeah, it's my first time, sir.
It is your first? Are you sure?
Yes, sir. Yes, sir. My first time on suspended
Okay.
license.
All right. Do you swear to tell the truth?
I swear to tell the truth, this one.
And do you wish to resolve your case today, waive your right to an attorney in the trial?
Yes, sir.
Anybody forcing you to do this?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
And do you want to plead no contest to one count of driving while license suspended with knowledge?
Yes, sir.
The courts can accept this plea of no contest, find that it's freely and voluntarily given. The court is going to adjudicate him guilty, order court costs of $293, and give him 6 months to pay that. I'm going to dismiss count 2, failure to use a designated lane. Okay, Mr. Shidney?
Yes, sir. Sir, is there any way you can put adjudication without, or it's adjudication?
Well, I would consider that if I had your DL record, but I don't. I don't have a driver's license record, and so I don't know how bad your driver's license record is.
I have it here, Your
Oh,
Honor.
you do?
Yes.
Can you print it, or do you want me to come over and take a look?
I can print it. Whatever you want.
That would be great if you could print it.
Yeah, that's not a problem.
Kelly's at the main jail.
Okay, thank you.
How much time did you give me? Certified?
6 months to pay it.
Oh, no. How much time? Jail time? Time saved?
Yes.
So I was in jail since from July. That's my...
Okay, he can hear you. You can speak to him.
I can tell him about it.
He knows.
$1,000 on the possession of, right.
So it's 1,000 on count 1.
And then,
all are
correct. We're printing up your DL record right now, Mr. Shindney.
Sorry?
We're printing up your DL record right now, so I can take a look at it.
You're printing your.
Oh,
your driver's
okay,
license.
okay, that's fine, sir.
Yeah.
Hey, that ain't for you.
No, Mr. Sidney, I'm going to adjudicate you.
Yeah. Okay, sir.
Okay. And
Yes,
I'll
sir.
dismiss on count 2.
Okay. All right.
On Diamond Sidney, I adjudicated him guilty on count 1, 293 court costs, 6 months to pay, and I did dismiss count 2.
Okay.
What about Morgan Rubio? I do not, I see him on the docket, but I do not see a file on him. Has that case been completed? Sir, what is your name?
My name is Richard Nicholas.
Okay, you're next.
Thank you.
Anybody have any money, money,
None.
any information on Morgan Rubio?
One moment, Your Honor.
Right.
Let me see what that's about.
No one is responding, so I'm assuming he either bonded out or...
No, there might be something else holding him.
He bonded? Okay, so we're deleting Morgan Rubio from the docket.
Actually, it's a she.
And we're going to go to Richard Nicholas, who's at the Conte facility. Mr. Nicholas, you are charged with driving while license suspended and revoked. And a violation of probation. On the violation of probation, you've been set no bond by the court. And on the, looks like on the driving while license suspended, you have a $5,000 bond, which was set in August of 1991. Can we determine when he's going to go before the probation judge?
I believe that's Thursday, sir.
It is Thursday? Okay. All right, sir, I'm going to not change anything before you go before that judge, okay?
Yes, sir.
All right, good luck to you.
Thank you, sir.
Okay.
Thank you, Your Honor.
And you want to go to the main jail, and I think we have...
Come on, Kelly.
Kelly.
Yes, Judge.
Okay, and Mr. Kelsian, you were charged with aggravated assault on a police officer. I did find probable cause. Your bond is $5,000. You're charged with a resisting officer or without violence, a misdemeanor. Your bond is $100. I find probable cause. And you're charged with fleeing or attempting to elude a law enforcement officer. Your bond is $1,000, and I find probable cause. As to the warrant issued by, let me see, it was Judge
Jeffrey Cohen there on that.
Jeffrey Cohen for attempted first-degree murder. Just give me a minute, I'm going to review the affidavit, which is attached to the warrant.
You getting to work? Last year was the second year. No, last year was the first year paying off on my birthday. What they should do, like I'm sure you so now we're on the birthday. Because I know when I first came, we had two floating
They have reviewed the probable cause affidavit. I find that there's probable cause for the warrant.
And I'm sorry, Your Honor. Well, the court, pursuant to the rules of criminal procedure, the defendant may not be held no bond unless the court finds that there's proof evident presumption great. I would argue, based solely on the arrest affidavit at this time, that there is proof evident or presumption great. There's a sworn statement taken from the alleged victim who identified the defendant as the person that shot him. He has known him his entire life, thereby enabling him to identify him. He informed the police that Mr. Kelly threatened him moments before the shooting and then witnessed Mr. Kelly in possession of a firearm at the time of the shooting. Additionally, he mentions that the alleged victim required emergency surgery due to the extent of his injuries, Your Honor.
Well, let me ask everybody, because maybe I was under the misunderstanding that this is strictly a probable cause hearing, a magistrate hearing. Let me just finish. And that the judge can set the bond if it hasn't already been set. Another judge has already looked at this and set a bond. And my understanding is that the defense at any time then after that can go before the judge that is assigned to the case and ask for an Arthur hearing, where asking for the court to set a bond. And at that point, the burden is proof evident presumption is great by the state, and the court must find that.
Your Honor, if I may, just as an example, this is how Judge Hurley's been ruling, because it's been agreed upon, and there's actually case law, that the court at the first appearance must still find proof evident or presumption great. But, and what Judge Hurley's ruled, and this has been supported by a case in the 4th DCA, Kill v. State. And, Your Honor, what Judge Hurley has found is that the state must meet that burden at first appearance. If the state meets that burden, then the defense can file for an Arthur hearing in the assigned division, where the state can satisfy the burden again. The defense, if they want to, can present evidence to try to defeat proof evident presumption great. And I don't have to go further to explain Arthur hearing. I know, Your Honor, from years of representing you're fully aware what an Arthur hearing entails, though, so I'm not going to go into that.
Right.
But yeah, Your Honor, it's pursuant to Rule 3.130 and D, which covers the first appearance and pretrial release, and Rule 3.31 subsection A.
What does it say?
Your Honor, it says, well, 3.130 subsection D states it's under a pretrial release. The judicial officer shall proceed to determine conditions of release pursuant to Rule 3.131. Going to Rule 3.131 subsection A, right to pretrial release, unless charged with a capital offense or an offense punishable by life imprisonment, and the proof of guilt is evident or the presumption is great, every person charged with the crime or violation of municipal or county ordinances shall be entitled to pretrial release on reliable conditions. So that has been interpreted to mean that since that language must be followed at the first appearance, that unless we have a PBL or capital offense and the court has found proof evident presumption great, defendant's entitled to a bond. On the flip side, if a defendant's been charged with a capital offense or punishable by life, and the court has found proof evident presumption great, he is no longer entitled to a bond at the first appearance.
What the question I have is that if he had been arrested last night, there was no warrant, he was just arrested by the police during a felony investigation, brought in, and I can understand it, but there has been a Judge Jeffrey Cohen, who has reviewed the affidavit and actually prepared and issued a warrant stating no bond. So I don't believe that at this point that I can go behind that warrant and that finding and change the bond. He would have to go back before Judge Cohen and...
Well, he can't go back before Judge Cohen. See, this case actually, and that's the other issue, this case hasn't been assigned to a judge. Judge Cohen signed the warrant.
Right.
Now it'll go to the clerk's office and they will assign a case number and a judge.
I would think that he would have to go before that judge, whoever it's assigned to, on an Arthur hearing, but I don't believe that I can do anything on that.
And I certainly understand the court's position. I just didn't want to proceed without the court at least having an opportunity to see the affidavit.
Okay. All right, so you're being held no bond on that count, on a warrant for a violation of probation, and on one other warrant and two other capiases. One is for tampering. Do you understand that, sir? Mr. Kelly, do you understand you're being held no bond on those counts?
Yes.
Okay, thank you very much. All right. Now, I have...
Mr. Kelly, we're going back this way.
I don't think that I can make any kind of finding.
Well,
Yeah.
and I just want to put it on the record, because the case laws relied upon, I think the case is Brackett v. State, that the court can rely on just an affidavit in finding proof evident presumption great. And I've no doubt the court's already aware of that. I'm just making that record, Your Honor.
Okay. Yes, along with police reports, etc. But let me ask you, Natalia Johnson, I still have...
Paul Ryan.
Paul Ryan?
It's a VOP. I could check in the system to see if we have a... I could check to see in Odyssey if we have a copy of the warrant.
Yes, on those other ones where they're... See at the top? There's 3 counts where nothing is... I found probable cause, and here are the bonds. Yeah. Okay, and on Nathalia... Ma'am, Natalia Johnson? Is that you, ma'am? Let's take a look what is going on here. Okay, again, she is, a violation of probation has been issued, and she's being held no bond.
Yeah, it looks like on 2 separate cases. She's also being held on the...
I'm going to look at the other one. Okay. Ma'am, you have 2 cases. On both cases, you have several counts, and you're being held no bond based on violations of probation. Thank you very much. Do we know when she'll be appearing before the court?
She will get, it looks like she will get a date now, Your Honor, that you're sending it to Judge Robinson.
We're going to send it to Judge Robinson, and your violation of probation will be set for a first hearing, ma'am. Thank you. And then we have Robert Khalib would be the last one.
Yeah, I don't even know when it's being
He's
reset.
already been reset? Yes, you're correct. He has been reset. Okay.
So I think that's it.
That's it. All right.
Pick a date.